Hello, this is TDN Africa Media and I am Amadu Esbar. This is the program Legal Matters coming to you on TDN Africa Media. This is a maiden edition on legal matters. We talk about issues surrounding the rule of law, human rights, and that has got to do with the law itself. And today with me in the studio, I'll be talking to Mr. Emmanuel King. Emmanuel King is a barrister and solicitor of the High Court of Sierra Leone, legal and administrative director, Amadu Mining and Co. Limited, Deputy Secretary General, National Scramble Association of Sierra Leone, and a practitioner with the Nicole Wilson and Co. Malaika Chamber. Mr. King, you're welcome to the program Legal Matters.
Thank you, Mr. Barr. Thanks for having me.
Thank you. Today we want to look at the law itself. To start with, we want to talk about law as a career. How do you describe law as a career? Giving us a background about yourself and taking us through your journey in the field of the law study itself.
Okay, first of all, I would like to start by saying the practice of the law is a multiverse. You know, like we have the universe, which is a very big space. You have to think outside that. The law is wider and far more broader even than the universe. A career in the law, anyone who wants to pursue it has to really prepare their minds for things like discipline and control and determination and hard work, because it entails really a lot. I have started off by saying it's a multiverse, which means so many things are underlying when you want to pursue a career in the law. So, for instance, even at the inception, when you want to become a lawyer, in this part of the world, it is really very, very tedious. You have to go through your law course, which for us, you have to go to the University of Sierra Leone or some other institutions, and ours is laden with a lot of modules which you would have to study, a lot of law modules which you would have to study. And for some institutions, some of these modules, once you fail a single module, you cannot qualify as a lawyer in this jurisdiction, because you will not have an opportunity to sit to that module again. And so you will not be accepted as a student in the law school, where practitioners are really trained to face the profession, or to, as a matter of fact, be accepted into legal practice in Sierra Leone.
So take us through your own journey being a lawyer.
Yes, well, for me, before I ventured into the legal field, I had some other discipline. As a matter of fact, I worked with a mobile company, and I also worked for a bank, the Sierra Leone Commercial Bank. So I had some other experience. But I always saw myself from childhood as a lawyer, that I'd like to be a lawyer when I grow up, because I wanted to support people to pursue their rights in the court of law. I wanted to represent people in my community and be someone who they can look up to, who can challenge for their rights in society. So despite the other disciplines that I subscribed to over the years, I decided that, well, for me, these ones are too boring. I think the law is full of life, and I have to go into the law. So I opted to study the law. I was enrolled at Frabe College, and I qualified from Frabe College, and I went to the law school. And all through these years, it was really challenging. You know, it challenged me in a number of ways. Challenged me financially, you know. As a family person, your commitment is not only to your studies. You also have to provide financially for your family. And so all these challenges, coupled with the fact that you have to study to actually become a lawyer. And as I have said in my opening statements, becoming a lawyer in this part of the world is really, really challenging, because ours is a completely different system. Ours is still decadent. You have to study the books physically. You know, we have challenges with social media, we have challenges with data. You know, most students cannot afford subscribing to the internet for materials because of data challenges. They do not have the resources to pay for the data required for their research. So they have to like go to the libraries, you know, and seek out books to study.
So the long and short of it, it has been a very hectic journey.
Yes, of course it is. It has been very, very hectic. And it also has to do with the psychology, because in Sierra Leone, we over the years, we see a number of students will be enrolled into the Sierra Leone Law School. For instance, now 100 students are enrolled. And when the pass list will come out, you only see 10 or 15 students passing.
Wow.
And the rest will fail. So you start to imagine, even when you are at the university studying law, that when I get to law school, it's going to be seriously challenging, because we see people fail at a very alarming rate and in huge numbers. So I have to get my act together, I have to study, I have to prepare very, very well when I get to the law school, so that I will not be among those who would fail. And as God would have it, I was among those who just took the exam at one go and passed. And now I'm a legal practitioner. The legal practice in itself is quite different from when you are studying, because you are now faced with real life situations.
Okay.
You know, most of what you are studying will prepare you for these real life situations, but they will not prepare you in such a way that the reality does. You know, because the practice of the law will challenge you in unimaginable ways. You have so much workload.
Oh.
And if you are a success-driven person, you want to succeed, you have to put your shoulder to the wheel, you have to be highly determined, you have to be very, very hardworking to make sure that you surmount this workload. Excuse me.
Okay. So all right, the program you're watching is Legal Matters, coming to you on TDN Africa Media. If you're just joining us, don't forget to drop your comments and your views in our comment section. I'm with Mr. Emmanuel King, who is here to discuss with me about the law itself. So now, let's talk about understanding the law. Knowing the law or knowing about the law is quite different from understanding the law. I suppose I'm right.
Yes.
So how do that happen? Understanding the law from the lawyer perspective and understanding the law from the common citizenry perspective.
Okay, with the study of the law, you are trained as a legal practitioner to be able to interpret rules, to be able to interpret laws, regulations, and statutes. You're actually trained for that. We have statutory rules of interpretation, which you are taught in school. Okay, the layman is not exposed or open to this kind of learning, because he's not a lawyer. That's why we refer to them as a layman. When you are not a lawyer, you're a layman. So, because you are not exposed to this form of learning, like for instance, I have just mentioned the statutory interpretation of the law. You know, we have tools that we use to interpret the law. So for instance, now you will hear someone be making reference to the 1991 Constitution. Go to Section 23 of the 1991 Constitution, it will tell you about the presumption of innocence. The person actually can read English language. So if he goes to the 1991 Constitution and he reads Section 23, you will now see what the person is talking about, presumption of innocence. But you need to have the skill to now interpret what the drafters of the Constitution were trying to achieve.
And that comes in the lawyers?
Yes. What they were trying to achieve when they were drafting this particular aspect of the law. So therein comes the statutory interpretation of rules. Okay? Therein comes these skills that the lawyers are trained to have. How you look behind the spirit and intent of the rules and the laws of the drafters. Because we have people who actually draft these things. Parliament is charged with the responsibility of legislating for the state.
Okay.
Yes, and how do we pick members of parliament? We vote for them by constituencies. So they go to parliament and represent us. In their representative capacity, they make laws for the land by which we should abide. Behind each of these laws, there is a particular spirit, there is an intention why this law was promulgated. So even though it is written in plain English language, But you have to understand the intention, the spirit behind this law. Why was this law enacted? Okay, laws are enacted for a number of reasons. Okay, laws exist in society for a number of reasons. Okay, so it is these reasons that lawyers tend to look at, that they tend to espouse when they argue in court. They use technicalities to come to these reasons, whereas the layman cannot understand that. He will only be able to look at the English side of it. Okay, we have laws which are very, very direct. We have laws which are very, very direct. We have strict liability rules also. Laws which, as long as you are found wanting of these laws, they need no further interpretation.
Can you at least highlight some of these laws?
Yes,
because it is for the benefit of our viewers.
For instance, now a prohibition on public smoking.
Okay.
Yes. So if there is a prohibition on public smoking, if you are found in public smoking, then you are in violation of the law. So
that's a direct...
Yeah, that is a strict liability offense. A lawyer cannot now go to court and start using technicality to overturn that. Because when it's a strict liability, you do not have to argue. You understand? Mm. So it's direct. If the policeman meets you on the street, you are smoking, then you violated a law. Okay? So it's not as straightforward as a scenario where someone is alleged to have committed murder.
Okay.
Yes, so that is not strict liability. It would have to be examined in court. This person, first of all, would have to be presumed innocent because the courts or the law will now have to look at the circumstances of the case. We'll have to look at cause and effect, causation. We have to look at all of these different things before the law or the court can come to a decision or a determination on the matter that this person is actually guilty or is innocent. So there is a marked difference between someone who commits murder and someone who is smoking on the streets.
And just after that, because you really need to give the direct laws. You said something about the prohibition of public smoking.
Yes.
That is one. Is there any other ones that you may like to highlight? Because people really need to know about this.
Yes. Well, you have a number of strict liability offenses in Sierra Leone. For instance, a drunk driving or driving under the influence of alcohol. Okay, it's also a strict liability offense.
Okay.
Driving under the influence of alcohol. So once you are found driving under the influence, how do the police establish that you are found driving under the influence? They have what is known as a breathalyzer. Okay? Mm. So once they suspect that you have been drinking, they will now use the breathalyzer and just pass it through your nostrils or your mouth. And it will now detect some substance of alcohol. And once that is established, then you've
committed a traffic offense, so to speak.
You have no other defense. You cannot put up a defense. Because this is now a machine that says that we found traces of alcohol on you and you were driving. And you cannot go to a nightclub, drink and drive. You cannot be in your house, drink, and then you go to drive. So this is what I was talking about, the spirits and intendment of the law. So the intention of the law is not your drinking. You can be in your quiet place in your house, you can drink and enjoy yourself.
Okay.
The law is trying to forestall a situation wherein you drink, you've now lost consciousness, so to speak, you go and drive, and while driving, you know, there is this sweet breeze that blows while you are driving, and you now forget yourself. You lose control of the steering wheel, and you cause an accident to happen, which will cost someone his life, or you cause some very serious damage to someone. So this is the spirit and intent of the law. While they were passing this law in Parliament, the parliamentarians or the people who gave them the mandate to pass these laws, they were trying to forestall something like this from happening. That you would drink, go and drive, and then commit an accident which will cost even your own life or the life of a pedestrian.
Is the Sexual Offences Act part of one of these laws?
The Sexual Offences Act the sexual offense. I'm trying to look at a specific offense under the Sexual Offences Act, which is a strict liability. Yes. Sexual penetration of a child.
Okay.
Yes. Sexual penetration of a child. So you cannot put up a defense. You cannot put up a defense that, well, when I looked at the child, she looked matured.
Oh.
Yes, and she gave consent to the act of sexual intercourse. The statutory definition of a child is someone that is below the age of majority.
And what's the age?
For Sierra Leone, it is 18 years.
Okay. And
Okay.
do we have a age for consent when it comes to sex?
Yes.
How much is it?
It is 18 and below.
18 and below?
And above for consent.
Okay.
So anyone who is 18 and above can give consent to sex.
Okay.
But if the person is below the age of 18 years, it matters not if the person gave consent. It matters not. It matters not the physical features of the person, of the child. I will say the child because technically anyone below the age of 18 years by law is a child in this jurisdiction.
Okay.
Okay, so if you have sexual engagement with any child, whether the child gave consent or not,
It's a strict liability.
it's strict liability, and you will have to serve time for that.
And does that does that reference the Public Order Acts? Is that also a strict liability?
We have certain offences under the Public Order Act that could be deemed as
and what
strict
are they?
liability. I have just mentioned one: smoking in public.
Public, okay.
Yes.
Okay.
Smoking in public is or public
And
smoking.
how about
a strict
public
liability.
nuisance? Is this?
No, public nuisance is not strict. It's not strictly a strict liability offence because you would have to prove certain elements to show that, as a matter of fact, the person was causing public nuisance.
Okay. The program you're watching is Legal Matters, coming to you on TDN Africa Media. My guest in the studio today is Mr. Emmanuel King. We're talking about legal matters. We're going for a short break and we'll be back. Welcome back. The program you're watching is Legal Matters, coming to you on TDN Africa Media. If you're just joining us, don't forget to drop your comments in the comment section as we're discussing about issues that has to do with the law. And in the studio with me, I have Mr. Emmanuel King. Mr. King, you have elaborated a lot on law as a career, and that has got to do with strict liabilities and other laws. Now, let's talk about understanding a local standing itself. We want to talk about that because we know there is a recent matter which I believe, I presume you must know about, the matter that has got to do with Saidul Nalo and 5 others, including Dr. Samura Kamara. And in the last judgment, they were supposed to go on a locus finding, so to speak. So what's a locus standing to start with?
Okay, I think the phrase that you're looking for is what we call locus in quo.
Okay, locus in quo.
Yes.
Thank you for helping me.
Locus in quo. A locus in quo is when the court moves from the premises of the court to the scene of the crime.
Okay.
Yes. The court does that because evidence has been brought before the court which it deems that the court has to now go to the scene of crime to be able to understand the full scale, the material facts of the case. Okay, so in the case that you've just cited, the state versus Saiduna Law and 5 others, it is a situation without prejudice to the matter. It is a situation where so much has been said about the Chancery building, the reconstruction of the Chancery building in the United States.
Okay.
For a background to this particular matter, this case has to do with allegations of misappropriations with respect to a reconstruction of a particular Chancery building in the United States, which houses the foreign mission of Sierra Leone.
Okay.
Yes. So the foreign mission of Sierra Leone in the United States, the building that houses the, our diplomats and foreign servants, was in a dilapidated condition. And the government thought it fit to do rehabilitation and reconstruction of this particular building.
When you said the government, is it the current government or the past government?
Well, when I say government, is continuity.
Okay, okay.
So it has to do with the past government and the present government.
Okay.
This project covers both governments.
All right.
So the facts coming before the courts now show that both governments have been involved with this project.
Okay.
But this project was instituted by the then foreign minister, who is the now flag bearer of the main opposition party, Dr. Samuel Kamara, while he was foreign minister. So he birthed this project. Okay? So much has been said about this Chancery building. So that was just for background. So much has been said about this Chancery building in the evidence coming before the court that the judge, in his wisdom, now says, well, we need a locus in quo. The court needs to move and see at what stage the construction of this building really is. Because the evidence seems to be distorted. One witness will now say the building is at the 4th floor, while another witness will now say work has started on the 6th floor of the building. So because there is distortion, there is discrepancies between the witness statements, the court has decided to now go and see for itself. That is what is meant by locus in quo. So the court will now go and gather evidence by itself, physical evidence. They will go there physically. The judge will examine in the presence of the defense and the prosecution. So every single party in this matter will be present in the locus in quo when the judge will be there to get his own evidence for the court.
So what happens after that?
Well, without prejudice to the matter, I am saying this because it will be a legal infringement if I start to speak about an ongoing legal matter.
No, it's just
without that phrase.
Exactly, yes. I get it.
Without prejudice to the matter. When the court has now gotten its own evidence, it will now weigh it with the evidence that had previously come before the court.
Okay.
Yes, for proper determination of the matter.
And does that continue with the vote that the accused have made so far in the last ruling?
Well, what happened in the last ruling was that the prosecution had closed its case.
Okay.
And at the close of the prosecution's case, the defense opted to put in what we call a no-case submission.
Oh.
Yes, this means that the case of the prosecution has not been made. The prosecution has not been able to substantially make a strong case against all defendants because all the defense counsel put in a no case submission.
Okay.
Yes. So they all said, defense for all 6 accused persons said, the prosecution has not been able to convince this court that we should go forward with this case because the evidence that they brought forward is not strong enough for us to continue with this matter. So we believe, as a defense, that there is no case to answer.
You said we believe. Are you part of the defense?
Well, I'm saying we believe because I'm figuratively saying it because I'm not putting myself in the position of the defense.
Okay.
Yes, that this is their position, that they believe that the prosecution has not made its case. And so the defense do not have a case to answer.
Okay.
Yes, so it was that no case to answer that the Honorable Justice of the Court ruled on.
Okay.
As a matter of fact, he did not side with any of the no case submissions.
Okay, that is to say, it dismissed the no case submission.
Yes.
And then the votes from the accused, because they had to take a vote, to make a vote, right?
Yes, it puts them on their election.
Election, I beg your pardon. You know, you have to help us. This is legal matters.
Definitely.
You have to help us understand these things.
So it is procedural that after the no case submission had been turned down or dismissed or overruled. After the no case submission had been overruled, the judge now has to put the defendants on their election as to what direction they want the case to go. So they now want the judge to come to a determination of the matter there and then, or they are going to mount their defense.
Okay.
Yes. So in a criminal prosecution, in a criminal trial, the prosecution will go first. They will now make their case against the accused persons in the dock. At the end of their case, it is now the turn for the defense to make their own case. But in that intermediate stage, the defense can put in what we call a no-case submission.
Okay.
If they believe that the prosecution has not made a strong case, which every single defense counsel for all accused persons did in this instant case. Okay? So, it is also the prerogative of the defense to launch a defense for all defendants when the no-case submission has failed. Or, if the accused persons elect to now pass the baton on to the judge, say, okay, at this stage, you can now make a determination on the matter. Then the judge can go ahead and look at the evidence that has been brought before the court. But it will be ill-advised for any accused person, immediately after your no-case submission has been overruled, and you now tell the judge to make a determination. Yes, because when your no-case submission has been overruled, it is an hint to you by the judge that I see some elements of a case to answer. Yes, so you now have some things to answer in this allegation. Because what the prosecution has brought before the court looks as if it is now holding up. So you have a case to answer. So you cannot now tell the judge, okay, now come to a determination of the matter when you have not presented your own case before the court. That would be a dangerous move. So I believe every single accused person elected for their defense counsel to mount a defense in their state.
Okay, so already that you've explained to us what's locus and co. I think I now know the legal, and of course you also made me realize that we have what we call strict liabilities.
Yes,
that's a very good insight into the law itself. The program you're watching is Legal Matters, coming to you on TDN Africa Media. I am your host, Amadu Esbar. We're taking a short break. We'll be back soon. welcome back. The program you're watching is Legal Matters, coming to you on TDN Africa Media. I am your host, Amadu Esba, and in the studio with me, I have Mr. Emmanuel King, who is here to analyze the law for us. Welcome back, Mr. Emmanuel. So, Mr. Emmanuel, now let's go back to law as a career. The reason why we really have to talk about it again once more is the fact that there is this misconception about too many lawyers in the country, whereas we have other careers. What's your reaction to that, being a lawyer?
Yes, well, I do not see people questioning the fact that we have too many accountants, or we have too many engineers, or people in other disciplines, but they are really particular about the law. So we have to dispel this misconception that there are too many lawyers. It's my view that we do not even have enough lawyers in this country.
Oh, you think so?
Yes, because many people are starving of legal representation.
Oh.
Yes, many people do not have access to justice. Yes, so we need more lawyers, but that is not the only reason why we need more lawyers. We have very many areas in society, in our governance structure, in our state structure, that we need legal people, legally minded individuals, legal practitioners, to be a part of these institutions, to be a part of these sectors, so that these sectors will be run perfectly, so that these sectors will be run admirably. But the absence of people with legal knowledge in very many government institutions is part of the reasons why we see a lot of institutions not operating in the way they are supposed to operate.
So somebody will always say this, yeah? What is the benefit of having too many lawyers when we have matters in courts? Yeah. Too many matters in court, and you have too many lawyers.
I was expecting that you were going to mention matters in court. That's why I did not speak to it initially when you asked me the question. I wanted you to lead me on. Because this is the perception of people that lawyers only operate in the courts.
Okay.
No. Lawyers do not only operate in the court.
Okay.
As a matter of fact, the law is divided into solicitors and advocates, or you can also say barristers. Okay? So we have lawyers who, their area of specialization is solicitors' work.
Okay.
They can do documents, okay? Legal documents, business documents, corporate documents, real estate documents. Then you have advocates. Each of these aspects of lawyering or a career in law is quite wide, it's quite vast. You understand? So for instance, now you have a corporate outfit. They need a legal sector. They need a legal team. They need, for instance now, they have loan facilities in banks. Okay? The people that do due diligence to make sure that the individuals who are beneficiaries of these loans are creditworthy should be legally minded. Okay? Because you have a lot of due diligence, KYC that you have to put into these projects, that you need legal understanding, you need legal tools to be able to come to the conclusion that as a matter of fact, this person is creditworthy for us to accord him this loan.
So you've actually said that we need more lawyers than we may need any other discipline. Because you think people need legal representation.
Yes, access to justice.
Yes. So you as a lawyer, do you give out what you call pro bono?
Yes, I do. As a matter of fact, I told you why I wanted to be a lawyer.
Okay.
Yes, I want in my community for people to now come to me with their legal concerns, and I be the one to represent them, to to seek redress for them in the
So
courts,
doing
to
your
seek justice for
so
them.
doing your pro bonos, how do you which types of cases do you normally look at? Because being a lawyer, because you wouldn't just want to take up a matter just like that, I believe.
Yes, you have to take up matters within your areas of competency.
Okay.
Okay, so as a lawyer, every lawyer is strong in a particular aspect of the law.
Okay.
Okay, so I would not go and take a matter which is outside my competencies, for which I cannot appropriately represent the client. So for instance, now someone is bringing a matter that touches and concerns oil and gas. You know, a conflict in oil and gas. I am not a specialist in oil and gas law.
Okay.
Yeah, so I would now have to refer that person to someone who is a specialist in oil and gas law. I would seriously doubt whether that person will now give his service as a pro bono.
We make music exclusive, brothers.
MP Sounds. Sweet home, come back home. Come back to Africa. Sweet home, come back home. Come back to Africa.
Greetings, family. I am in Sierra Leone and have successfully obtained citizenship with the help of African ancestry. May the Mende women whose lineage I am born into be pleased with me for returning home on their behalf. They were told they had entered the door of no return, but that has been proved wrong. We have come 360 degrees. It's our time now.
I did come home, melanin dripping like we never left. Black excellence, yeah, you know we are the best. 400 years away, you don't say why they pray for this day. Let us build each other up. Me famble come back home. Let's make Africa great. Black people come back home. Let's make Africa great. Black people come back
home. Sweet home, come back home. Come back to Africa. Sweet home, come back home. Come back to Africa.
Let's make Africa great. Black people come back home. Let's make Africa great. Black people come back
home. Africa's not black, you feel slavery, we are far from it. I'm glad the land is green, together we will succeed.
From a black people around the world, Africa belongs to all of us. Come back home, let's be strong, divided we fall, united we stronger.
Accept it, Africa's in your DNA.
But it's almost you give us alone man or you are Nigerian. Just listen, Emma wa Ghanaian. So divided we fall, united we stronger.
Sweet home, come back home. Come back to Africa. Sweet home, come back home. Come back to Africa.
Let's make Africa great. Black people come back home.
Yes, on the mix.
We make music.
Welcome back. The program you're watching is Legal Matters, coming to you on TDN Africa Media. We're sorry for that sudden break. We had a little bit of technical hitch in the studio that we needed to fix. But we're back and we're almost at the climax of the program. I've been your host, Mr. Amadu Esba, and with me I have Emmanuel King, who is a legal practitioner. He's been in the program helping me to discuss matters that has to do with the law itself. Now, we're about to bring the curtain down, but I just want us to deliberate on, without prejudice in the matter, the case that has to do with LJ. He's been found guilty of 4-count charges. From your own perspective as a lawyer, what's your take on that matter? Without prejudice to the matter itself.
Well, at the inception of that matter, when they were at the preliminary investigation stage, I used to attend court because they were at the magistrate court. Magistrate court number 1 at Pademba Road. So I used to follow that matter. It was for robbery with violence and other related offenses. Even during the preliminary investigations, which we call PI, because for the purposes of those who are listening, a PI is a small trial before the magistrate determines whether there is enough evidence to transfer the matter to the High Court. So in this evidence gathering stage, this preliminary investigation stage, some witnesses came before the court, giving information to the court. They were deposed. So they gave certain pieces of evidence before the court, and the magistrate thought that, well, I have seen enough, and I think there is enough evidence for this particular matter to be moved to the High Court. Okay? And the matter was transferred to the High Court before Justice Fisher, and both sides argued their case out. The prosecution made its case, bringing all its witnesses, and the defense tried best they could to see how best they could refute. But in my considered view, like all lawyers understand, in a criminal matter, the threshold is really very high for the prosecution to prove its case. So, without prejudice to the judge's decision, I think the judge worked with the evidence that was before the court to now find LJ guilty on all counts. This is the position of the court. A sentence has not been reached yet, so we now await what will be the mitigating circumstances that the judge would consider in coming to the sentences that he wants to give to the accused person. But because the matter is still ongoing, has not come to its proper determination yet, I will be constrained to speak to the merits
of the matter,
of the case in its entirety in such a public forum. So for the purposes of that, I will stay to this.
No, I do understand.
Yes.
I do understand. Although some people are assuming the minimum jail time for robbery with aggravation normally goes around 15 or so. Is it true, according to the law book?
Well, there is a stipulated.
Yeah.
There is a stipulated term of sentence for. It's not robbery with aggravation that he was charged with. He was charged with robbery with violence.
Oh.
Yes. He was charged with robbery with violence. And he has been granted bail before in the magistrate court for other matters. But I remember Magistrate Kekura, who was presiding over the preliminary investigation previously before Magistrate Mark Gegba took over. He said that the charge was too grave for him to admit the accused person to bail. Yes. So taking that into consideration, I think all this while he's been in custody while attending trials. I think the judge will take that into consideration as time served.
Oh.
Yes.
Okay.
And definitely, I think his sentence would be minimized. They will not give him the maximum sentence. I'm quite sure of that because he served some time while attending trials.
Oh, okay. It's been a good time talking to you. You've really deliberated on lots of topics. We talk about law as a career. We talk about understanding the law, about the locus code. Thank you for making me get the legal term of that particular word. It's a good time.
So it's quite different from locus standi.
Okay.
Locus standi.
Okay, there's really a locus. Oh, yes. So what happened is a locus in co.
Yes.
Okay, we'll have you.
What's going to happen because the court has not moved yet to the scene.
Oh.
Yes.
Okay, but the court is supposed to move to the scene.
Yes.
They were supposed to have done that before the 17th.
There was some administrative glitch somewhere.
Oh, okay. You being an administrator at most of the court, I do believe you understand what's going on there. It was good talking to you, Mr. King. Thank you for being on the program. Thanks for being. So, what would be your parting statements? What do you think about TDN Africa Media?
Well, I am quite impressed that we have an alternative medium where voices cannot be stifled.
You make me feel big. Thank you.
Where people will see the opportunity to come and air out their views, share opinions, and we are grateful for this.
And this is why we're here, to give out on biased news and make sure that
you should encourage more unbridled opinion.
We would definitely, and that's what we're here for. Thank you so much for being on the program Legal Matters. We look forward to having you again on our subsequent programs. Thank you so much. The program you've been watching is the program Legal Matters. Came to you live on TDN Africa Media. Every week we'll be having this starting 11:30 in the morning to 12 in the noon. Thank you so much. Stay glued and stay connected to TDN Africa Media as we bring you entertainment, news, and education.